Well, welcome on a Thursday afternoon for most of us and morning for some of us, including me, actually. I'm in the central time zone today. But we're going to give us about maybe another minute, minute and a half, and we will get started. I always ask those of you who've been on these before that you can hear us, or me in this case, and see the screen. And want to make sure that's the case. If you could maybe raise your hand just to make sure everything's working. Thank you, thank you. Make sure the technology is good, so appreciate that. Got another big group today. Had a great group on Tuesday, and people either told their friends or if they couldn't attend Tuesdays, they signed up for Wednesday or Wednesdays for today. So that'll be good. So give us about another 30 seconds and we'll get going. All right. Well, I'm going to go ahead and kick us off. So for those of you who don't know, I am Brian Klontz, president of Charitable Solutions. We've had the mostly joy of doing these webinars now for over 4 years. What started as a 2 or 3 month sort of COVID bridge to actually interact with people and hopefully provide some helpful resources has, I guess, become a thing. So I think this is our 51st one, 52nd webinar, and so glad to be joined today by Lindy Nash. Who'll be sort of going through all the more fun, meaty case studies today about bequests gone wild. Recent case studies you just can't make up. So Tuesday's call went great. I'm sure today's will go as well, if not better. I do encourage anyone to ask any questions in the Q&A box versus the chat. More than you want to know, a little bit funky for us to scrape these out of the chat. And we will take all of the Q&A from Tuesday, mush it with today. And as you know, from a housekeeping perspective, we do not send out the slides directly, but we do send out a link for the full recording plus the combined Q&A, which will come out early to mid next week. So with that, I'll just jump in very briefly and talk about weird things that we do here at Charitable Solutions. So Lindy, if you maybe would just advance that slide. So since day one in 2003, we have existed with one mission, and that is to help make charitable gifts happen that otherwise wouldn't. We have some somewhat strange ornaments to the tree necessary to sort of do that, that sort of have accumulated over time. And so I'll go through those quite briefly. We've got a team of 26 in our group, all in sort of these various areas. So sort of top right there, our Emergency Assistance Fund Administration. This is the smallest amount of what we do. I probably ought to end with that, but it's just how I've been doing it. So we do emergency assistance, third-party administration, as well as I created a separate national charity called the Emergency Assistance Foundation, where companies and large nonprofits as well can come to the Emergency Assistance Foundation, create a disaster relief or personal hardship fund. But because the charity is the legal owner and administrator of the fund, the company has no what's called breaking of the nexus between the employee-employer relationship. Then any contributions made to the fund from the employer, employer's foundation, employees, vendors, anybody are fully tax deductible as they would be for any other public charity. And then most importantly, to the extent that the employee or member of the charitable class qualifies because of a disaster or a personal hardship to receive a grant, then that grant is received tax-free. So we do a lot of this work. It's a totally separate group, have about 130, 140 staff on that side. And we do that globally. So you can sort of see some of the statistics there. I did over $300 million in grants for COVID alone, which is a little bit insane on a couple levels. So other thing we do, what we're doing today are in essence CE and other types of speeches for board staff, nonprofits, and donors. Do about 60 to 80 of those a year. Lindy and I were just talking about we're co-presenting at the State Street Conference, which is coming up soon. And then do a lot for community foundations, are probably 90% of at least what we do our work for, all things being equal. Then charitable appraisals. So if you are making charitable gifts, during life, or obviously life income vehicles, or through estates potentially. You might need a qualified appraisal by a qualified appraiser. So we have a team of 5 people. I do the crypto and life insurance. We have 2 people that do business appraisals, and then we have 1 person that does tangible property, and then 1 person that does precious metals. I guess that's 6 actually. Five. Um, and our tagline is, which we have been stumped once on it, that if you can give it to charity, we can appraise it. We had a horse inquiry. We don't do horses. We also don't do any real estate that is local. So if it's a local real estate, clearly that needs to be a local appraiser. But basically everything else we do. Then we do a lot in the gift annuity space. Anybody on the call here today knows the only 2 types of gifts that you can actually lose more money than the original gift are non-cash assets and gift annuities. So we've spent our entire, most of my career, but certainly entire firm's lifespan around these 2 areas. So we do 2 different things. One is we help charities directly that already have pools, providing consulting advice. I have an actuary on staff and have since day 1 as well, where we stress test larger pools, modeling, try to optimize for residuums. And then within, or perhaps even separate from that, are where very large gift annuities relative to the pool are being either offered to the charity or are already in the pool, and they're trying to figure out how to mitigate some of that concentration of risk. So we go through pool analysis around that. In some cases, not all, maybe half the time, reinsurance can be conducive for that, trade-offs for everything. And to the extent that that is useful, we look to see what the optimal level is, whether that's partial reinsurance, full reinsurance. And then also, if helpful, the client can select us for the design, placement, and brokerage of those policies as well. So it's the only sort of insurance thing we've ever done. And so we only sort of live in that one particular lane. For charities that aren't doing their own or don't want to do some gift annuities that are offered, we have the National Gift Annuity Foundation. So I super need to update this because it's growing very quickly. We are now over, I'm almost positive, 1,000 contracts. Last year we did 180 contracts. Perhaps interestingly, 60 of those, a third, were QCDs, which I would have never guessed in a million years. We are in all 50 states. We can do these for illiquid gifts. I think we're working on 3 right now that are real estate gifts. We've done one for S Corp. We have one, John Severson on staff did one, I think, for a couple thousand bushels of corn. So any kind of non-cash asset, but we also do them for cash or for marketable securities. Minimum size is $20,000. 100% of the residuum is passed back to the charity or charities that the donor was trying to give it to. So this gets back to making charitable gifts happen that otherwise wouldn't. Maybe you're a university in XYZ state. You don't want to register in New York because you probably shouldn't if you're not already there, or California or Washington or Hawaii. We're already there. So sort of as a one-off, or charities that don't want to do gift annuities at all because they can't get scale, we then in essence are a national aggregator in that space. And then the final thing we do, which is by far the majority, at least half of our time and work, is around non-cash asset risk management. So we do this either as consulting, kind of like we do for gift annuity risk management, to charities directly, just on an hourly fee basis, if appropriate. But about 95% of our time is working through charities I created also in 2003, the Decami Foundation and Decami Asset Trust. We only have ever taken in illiquid or complex gifts, no cash, no marketable securities in sort of their normal form. And then we also, strangely, never manage anything once it's liquid. So once it's liquid, we're horrible, needs to go out to the charity the donor was trying to give it to, which can be to other donor advised funds, direct charities, of course, community foundations, et cetera. So we're agnostic as to where the pass-through grant goes. Average donation last year at least was about 6.8 million. You can see 5.2 million there. So that actually bumped up a bit last year. And the average fee is still consistently about that 1.2, 1.3%. That's held back at the time of closing. These are not small gifts. We do roughly 1 per day. And then again, roughly 98.5 cents on the dollar, plus a little bit, is then granted in cash as a wire 30 days after we receive liquidity. You can see some of the other things here. We're also doing a national platform for charitable remainder trusts. So again, as an aggregator in that space, only if we are a trustee And we can have a full turnkey model or allow outside investment management for that as well. And the next slide, really brief. I just covered this, like what kind of gifts that Decamai works on. Again, this was just for last year. You can see about 161 gifts divided by the 1.1 billion. The biggest bullet point or nugget here on the whole slide is 100% of these gifts were declined. We do no marketing directly to donors, no marketing to professional advisors, none. We are saying, where is the donor trying to make the gift? Oh, it's to University XYZ or Community Foundation. Great. They are not able, for whatever reason, to take the gift in. Their gift acceptance doesn't allow it, concerned about risk, capacity, timing. On average, last year, it took us just under 3 days after we got due diligence documents to do full due diligence and receive business interest gifts. And it was about 6 to 7 business days for real estate gifts. So we crank it. So this is sort of our one trick pony thing, and we can move these along, get about 8 to 10 referrals a day. Only about 1 per day completes, but they're big. And so it's worth being able to help a good donor with a good asset wanting to do good things like this. Real estate, I just highlighted that. Lindy's going to talk about that in a case study. None of these are for estate gifts. None of these are for life income gifts. These are all outright current gifts. And the only other point I'd make here is that on business interest gifts, consistently, weirdly consistently, is 85 to 90% every single year. And I whined on Tuesday, I'll whine again today, that we get a lot of calls from nonprofits going, oh, we want to help with crypto. It's always crypto. We want help with real estate. We love crypto. You see it on here. We love real estate. You see it on here. 90% of the gifts are business interest gifts. I don't think this is true in a year. I've had a charity call and say, we really need help with business interest gifts. They're always focused on sort of the shinier things like crypto and maybe real estate. We love doing them. If you only did one thing, it's business interest gifts, more of them and bigger. So that's where I would start. That's the biggest, fruit on the tree. Eat that first. So little point there. The cash here, you can see a lot of cash. Those were only for capital calls for private equity holdings that we had in the business interest gifts. So we don't really get cash for cash sake. It's we need cash because there's a capital call or a new investment that's being made into private equity. So we're continuing to manage it. Again, once liquid, then it's being granted out. And you can see some other things here too. Some of the stuff with CRUTs and for real estate for CGAs. Again, that was for last year. We're probably triple that already this year. The only other trend this year that's sort of important to point out, by the way, 1.1 billion was not our record year. Our record year is 2021. We're on pace for this again, at least so far. Last 60, 90 days is everything. But the point I would make too is that we're very much seeing a lot more crypto activity in the first quarter. That's died off a little bit, but I think we're maybe at about 35 or 40 million in crypto gifts just in the first quarter. So that'd be the only trend that's a little bit different. I'll bet a ton of money we're going to end up at 85 to 90% will be business interest gifts by 12/31. So with that, I'm very happy to now pass it over to Lindy to sort of take us through the meat of these case studies. Known her for a long time. We are typically exhibit booth mates in some way at various conferences and heard her speak and saw a couple of the really cool blast emails that they talk about some of these interesting cases. And I said, Lindy, I'd love for you to come and sort of offer to our community some of the more interesting cases. And she was very gracious to do that. So Lindy, I'll pass it over to you and take us through the agenda.
Awesome. All right. Thanks, Brian. Hi, everybody. I am Lindy Nash. As Brian said, I'm a managing attorney here at Chisholm and Kilpatrick. It's so wonderful to be here today. I was thrilled when Brian reached out and asked if I could join in the August webinar. I am such a fan of Brian's work and his whole team at Charitable Solutions. They are fantastic. So it's really a privilege to be here. And I'm thrilled that so many of you want to spend your Thursday lunchtime with me before a long weekend. I'm really flattered, and I hope we have a good hour talking about some interesting case studies. And I hope everyone has some fun plans for their long weekend. So here's our agenda. I'm going to take 2 minutes. I promise just 2 minutes to tell you more about CCK Bequest Management and what we do. And then I'm going to get right into some really interesting case studies that we've found, and they hail all around the country from different courts. Today, we're going to be looking at Vermont, California, Arkansas, back to California and Georgia, and then ending in Pennsylvania. And we're going to cover whether wills can be partially valid. We're going to look at a case that talked about gifts of real estate to several charities and how they could share that. We're going to talk about a defective beneficiary designation. I know so many of you out there struggle with those POD, TOD beneficiary designation cases where you're filling out all that paperwork and what a headache it is. So we're going to talk about that. We're going to talk a little bit about interim clauses, or AKA a no contest clause. I'm sure most of you have seen those as well. And then we're going to end with a case where it really illuminates that you should always read the documents, always read the fine print. And this is Brian's a little disclaimer at the bottom, but I kept it just in case. So I am an attorney, but don't sue me. These are just tips and tricks and some interesting case law. So with that said, let's get going. So again, I promised just 2 minutes on this, just to tell you more about what I do. So I'm an attorney and I'm with CCK, and CCK is a law firm based in Providence, Rhode Island. But this bequest practice partners with nonprofits all around the country who are interested in outsourcing their bequest management. And what I mean by that is we handle all outreach, document collection, review, and we make sure that you get your distribution quickly and accurately, and that it's maximized in the process. This can be a really time-consuming part of someone's job. I know many of you out there are plan giving officers and you already wear a ton of hats as it is, and you don't have time to chase down that trustee who is hiding in the Grand Canyon, or Fidelity who's making you wait 2 hours to talk to somebody. No shade to anyone from Fidelity. Sorry, Fidelity. So we take that on for you, and it frees up your time. It protects your bequests in the meantime, and it lets you work with donors and add more bequests to your pipeline. I was laughing to myself when Brian sent out his email about this webinar, because the quote that he put on the top of the email was, I wrote it down, estate administration is a lot like kindergarten class. If the teacher isn't in the room, things go south quickly. So that's me. I'm the teacher. My team is the teacher, and we make sure that all parties are behaving as they should. So anyway, so that's a bit about us. If you have any questions, don't hesitate to reach out. But with that said, let's talk about our first case. So let's go over to Vermont, one of my sister states here in New England. So this case is the estate of Crowfoot, and it talks about whether a will can be partially valid. So here are some brief facts on the slide, but let me tell you a little bit more about Mr. Crowfoot. So Mr. Crowfoot met a young man named Sean Hammond, and he really befriended him. Mr. Sean Hammond was a teenager, and he was living in a residential treatment facility in Vermont. And Mr. Crowfoot volunteered there, and he became a mentor to Sean. He really became kind of a father figure and friend to him. Mr. Crowfoot would visit him. He visited him when he went to college. He sent care packages. Sean, I believe, went to college out of state, outside of Vermont, and Mr. Crowfoot, traveled to see him. Unfortunately, Sean was incarcerated for a bit of time, and Mr. Crowfoot even visited him in jail, funded his prison account, and again, gave him more care packages while he was there. Once Sean was released from prison, Mr. Crowfoot helped him find housing. He helped him purchase a car and manage his finances. So he was really there for him, and again, remained a friend and kind of strong presence in his life. They traveled around together. They went hiking. They spent a lot of time together. Sean eventually actually moved in with Mr. Crowfoot in 2018. So that same year, unfortunately, Mr. Crowfoot was diagnosed with cancer, and he became less able to care for himself. And Sean took on additional responsibilities around the house. So he cleaned the house, he would run errands, he would do whatever he could to kind of help Mr. Crowfoot do what he was no longer able to. Mr. Crowfoot's neighbor, Richard, happened to be an estate planning attorney, very convenient, and he prepared his several wills actually, but he prepared his final and former wills. So I believe there were 3 of them. And Richard was also named co-executor along with his wife, Tracy. So Richard and Tracy were the neighbors. They were co-executors of each draft of the will. So in these 3 different wills, let's see, they started being drafted in 2020, and in each version, in all 3 wills, there was an option for Sean to purchase Mr. Crowfoot's Burlington home. And again, this went through every single will, and every single will, this provision was there. And Mr. Crowfoot executed his final will from his bed, unfortunately, in February of 2021. The court later found that the testator was competent to execute that will, so there was no issue of competency here. There was no question of whether he had, he was in the right mind set to execute this document. That had been satisfied, that he did have capacity. So we don't need to worry about that here. But again, in that final will in 2021, he provided Sean with an option to buy the house for $40,000. As you can imagine, in this day and age, and even in the last couple of years, $40,000 is well below fair market value for a house in Burlington. And if he declined the house, if Sean didn't want the house, then it would be sold and the proceeds would be donated to a scholarship fund. So that was how the last will ended up. Sadly, Mr. Crowfoot died about 2 months later, so he died in April of 2021. And after his death, Tracy, the neighbor and co-executor, actually went into his house with Sean's permission. She asked for his permission. He said it was fine. She was looking for a container or a vessel for Mr. Crowfoot's ashes. And when she was in there, she walked by Sean's bedroom, and in Sean's bedroom, it was filled with brand new goods. So there were big boxes filled with sneakers, vacuums, lights, printers, clothing, everything still with the tags on it. It was clear he had gone on a significant shopping spree. She also saw buckets full of cash. Literally, there were buckets filled with cash on the ground, which was really interesting. She also saw and found piles of receipts, and those receipts showed that Sean had used Mr. Crowfoot's debit card to make purchases, including on the day that he died even. The receipts showed really that the last 3 months of Mr. Crowfoot's life, Sean had been withdrawing about $400 a day. So he was using Mr. Crowfoot's debit card pretty frequently and taking out significant funds every day. Apparently, as is the court record, the neighbors testified that they confronted Sean about all of this, and he admitted to this behavior. He admitted to using the debit card, he admitted to using the shopping spree, and even doing that on the day that he died. Naturally, as you can imagine, this resulted in a criminal investigation for elder abuse, and it also went into a probate proceeding to strike Sean's bequest due to undue influence. So this started in the probate court in the probate division in Vermont. So after a hearing, the probate division held that the option to give Sean to purchase the home for $40,000 was the result of undue influence. And therefore, the probate division struck only that provision from the will. So they kept everything the same. They just took out that one provision. Naturally, Sean was not pleased with this, and he appealed to the civil division. This civil division appeal was a 2-day bench trial. And what a bench trial is basically just something that the judge decides after seeing evidence on their own. So there's no jury, it's just the judge. So after a 2-day bench trial, the evidence that was submitted consisted of photographs, receipts, bank statements, and a forensic accounting. A forensic accounting, if anyone isn't familiar, is a very detailed accounting. So you hire someone to look at literally every penny that went in and out of an estate, or every penny that went in and out of a banking account or a checking account. They will track down where every single dollar went and when it was spent and by who and where. So a forensic accounting was really helpful here. The court also heard testimony from several different witnesses. They heard testimony from neighbors. Sean himself testified, and Sean actually had some character witnesses who spoke on his behalf and talked about how he was a good guy and had, wouldn't do something like this and had good moral character. Sean, when he testified, he explained that there was actually a tenuous relationship with the neighbors and Tracy, and he described Tracy as being a meddlesome annoyance and that she was just trying to kind of stir up trouble and make something out of nothing. He again denied stealing anything, even though he had previously told the neighbors that he did. So there was a lot of kind of back and forth and things that didn't make sense. He also claimed that the testator actually gave him the debit card to use whenever he wanted. He said he was able to, and that was part of their agreement. However, as you can imagine, the civil division did not find his testimony credible. So they found this provision in the will was a product of undue influence. They thought that Mr. Crowfoot was, based on the evidence, they found that he was very careful with money. He was known to be a penny pincher, and he had high moral and ethical standards. Therefore, because of that, they figured that had he known that Sean was acting this way in the last couple months of his life, he would have disinherited him and he would not have left this bequest to him in the will if he had known about this kind of evil and nefarious behavior. What's really interesting is that the one other piece of evidence they leaned on heavily was the fact that Mr. Crowfoot actually disinherited his own daughter. He purposely left his daughter out of his will because he felt as though she was only interested in his money. So they said, well, if he left his own daughter out of his will because all she wanted was his money, he certainly would have kicked Sean out of the will if he knew about all this behavior. So they again found that The only way that undue influence could be purged would be by voiding the bequest to the beneficiary. So again, they affirmed the probate decision, the probate division decision, and move forward. Well, my lights are going to go off. Excuse me. Okay, so then Sean appealed to the Supreme Court of Vermont. Of course, he's still unhappy, so he keeps climbing the chain and he goes up to the Supreme Court of Vermont. In the Supreme Court of Vermont, he argued that the record did not support that he stole from the testator and that the testator would not, have removed him otherwise. He also argued that the civil division erred in finding that undue influence was present because Mr. Crowfoot was of sound mind. There was no evidence that he, pressured him or coerced him into leaving a gift, and therefore undue influence wasn't even present. And then the last thing that he argued was that the civil division erred by voiding just the bequest to Sean. He basically said, if you think this is a product of undue influence, you should really be voiding the whole will. It doesn't make sense. There's no precedent for voiding just this one gift to me. So again, the Supreme Court went through all the evidence and they had 3 holdings that addressed each of those questions. The first one, the court found that the record did support that Sean stole the funds from the testator. Again, they looked at the receipts. There was a forensic accounting that was done. It's hard to kind of make that stuff up. It's pretty crystal clear, black and white. And again, they did think that the testator would not have given that bequest to Sean had he known about the stealing. So they found, they disagreed on that front. Number 2, they said undue influence and testimony capacity are separate issues, right? So, and I agree with that. You don't have to have a capacity issue to have undue influence. They can be totally separate issues. Someone can have capacity and still be unduly influenced. They really don't have much to do with each other. So that's what the court said there. Again, you can be unduly influenced and still have capacity. Usually in Vermont, the party who's asserting the undue influence has the burden to prove it. So here, Tracy and whoever else was petitioning, usually it's on them to prove that Sean was unduly influencing. But in Vermont, the burden shifts when there are suspicious circumstances around the execution of the will. So because the beneficiary, Sean, was a friend, he was a confidant, he lived with Mr. Crowfoot, he took care of him, there was this relationship of trust and confidence, the court found that Mr. Hammond failed to rebut the presumption. When he was on the stand and he was giving testimony, he had very little to say. The court and the attorneys were asking him, basically to prove it and to say, what do you have to say about this? And he really didn't say much at all. He either claimed he forgot, or he said, well, if that's what she said, or if that's what he said, then fine. He was very kind of nonchalant and didn't really care. So the court didn't like that at all. And again, found that he was incredible and his testimony was unreliable. And then lastly, when they talk about the partial avoidance, they found in the Supreme Court that partial avoidance is acceptable for undue influence because at the end of the day, it preserves the testator's intent and it effectuates their desires. The Supreme Court really talked about how it's their role and the court's role to make sure that the donor's wishes are honored. This last will and testament included 20 other bequests to 20 other people, and they ranged from $1 to $5 million. So how, unfair would it have been not only to them, but to Mr. Crowfoot, the donor, if they struck all of those other bequests just because of Sean's, poor behavior and bad choices. So it really didn't make sense to strike everything else. And the last thing, what was really interesting, again, going back to Mr. Crowfoot's daughter, if this whole will had been struck, it would have passed by intestacy. So it would have gone by the laws of intestacy, meaning to family members. His family member that was living was his daughter. And again, he really did not want to leave her any of his money. So the court looked to that and said, well, how unfair would that be if we struck this whole will, his whole estate passed to his daughter, who he specifically disinherited? That really doesn't make sense and it doesn't honor the donor's wishes. So that was the last kind of thing that they leaned on to decide to strike just this one bequest from the will. And then one other thing that's important for everyone to know is that the Supreme Court noted that this decision was keeping with many Northeastern sister jurisdictions that have also allowed parts of the will to be stricken. So they cited to cases in New Hampshire, Pennsylvania, New York, and Massachusetts, and they note that all of these other states do the same thing. So I thought that was really interesting to note. So what did we learn here? What are some lessons? So sometimes beneficiaries worry about raising undue influence or lack of capacity out of fear that the whole document will be thrown out. I know this is something that we talk about and think about here at CCK, and when it comes to protecting our clients and their requests, you have to keep that in mind because you're walking a very fine line. If you bring up the fact that there was undue influence or capacity issues, you run the risk of throwing out the whole will. And if the whole will is thrown out, there goes the charity's bequests, and there goes maybe several other charities' bequests, and you don't want anyone else being upset with you. So that's always a difficult decision. But again, the lesson here is depending on the circumstances, it's possible to strike one bequest from a will where undue influence is involved. It's possible just to take out that one bequest that relates to that bad actor, especially if you're in Vermont, New Hampshire, New York, or Massachusetts. I would recommend discussing this with an attorney. If you are ever in this situation and you feel as though your donor was unduly influenced or maybe didn't have capacity, you should talk about this with an attorney and see if it's worth filing a petition. All right. I see no questions, so I think I'm going to move on to the next case, but feel free to write in, send me any questions that you might have. Okay. Oh, wait, we have one. Would they default to a past will? That's a great question. So they might. It's not automatic, though. It is not an automatic decision that just because one will is the product of undue influence, that they would look back to an earlier version. So, classic lawyer response, it depends. And it really just depends on the court and the judge and the attorneys. But you can certainly ask for that and you can argue for that, but it's not an automatic thing. Good question, though. Okay, so let's talk about gifts of real estate. So this is the Stadel Art Museum versus Mulvihill case, which comes from California. And again, we're looking at a gift of real estate to several charities. So Bosch and Hudson were life partners, and they purchased together 4 San Francisco rental properties. In March 1994, Bosch established the Bosch Trust, making himself the initial trustee and funding the trust with his 50% ownership in the properties, his 50% interest. Shortly thereafter, Hudson established the Hudson Trust, which he likewise funded with 50% interest in each of the subject properties. Bosch died in 1995, and Mr. Hudson died several years later in 2019. Mr. Mulvihill was the trustee of both trusts. Therefore, he was responsible for the administration of both trust administrations and actually both estates as well. Bosch's trust left half of his properties to the Stadel Art Museum, which was in Germany. Hudson left his half to 4 US-based charities. I think they were all in the San Francisco area. So right off the bat, Stadel, which is the art museum, they demanded that Mulvihill distribute the properties in kind, aka by deed. So they wanted to receive those properties. They didn't want them to be sold and liquidated. They wanted to receive basically the deed to those properties. However, the 4 Hudson charities insisted that Mulvihill sell the properties and divide the proceeds into portions established by the trust. I know, at least for our clients and probably for most of you on the screen, most charities prefer to receive cash, right? Typically, you don't want a piece of property, especially a rental property, in San Francisco, you probably have to manage it and it might be a huge pain, but you do want the funds from liquidating it. So that's, probably where the US charities were coming from. Of course, Mulvihill, as the trustee for both, was torn. He was in a really tough spot and he had conflicting fiduciary duties to everybody. So what is he supposed to do? He had no idea. So he filed a petition with the court, basically seeking instruction. So he wrote to the probate court and said, I have this potential conflict. I don't know what to do. Tell me what to do. Help me make a decision. Do I go with what Stadel wants to do? Or do I go with what these other charities want to do? Help me, tell me what to do. So court instructed Mulvihill to sell the properties and distribute the proceeds to the respective beneficiaries. Based its decision on wording of the trust, which was super interesting. In the law, it's funny, every so often you run across a case and it turns on the word choice. So, what did they mean by and? What did they mean by the? And sometimes it can be annoying, but that's how it's done. They really look at word choice to see what was the intent. What did the drafter really want to do? And that's what the court did here. So they looked at the Bosch Trust, which said, with due consideration of the real estate market, my trustee is requested to sell the real property and items of value left over after the above gifts. There was no wording requiring an in-kind distribution, and therefore the court felt as though the donor wanted the trustee to sell the property. However, as you can imagine, Stadel was not happy and they appealed. So this made it up to the Court of Appeals in California. And again, they noted that it's their job to effectuate the intention of the trustor. That's what they want to do. They want to make sure the donor's wishes are honored. That is their job. Again, it cited the wording from the Bosch Trust and found that it reflected the general intent that property should be sold along with the rest of the trust estate. However, the word requested, and again, they really looked at the word choice, requested, in its common and ordinary sense, is not construed as an unwavering command. So requested is not a strict direction. It's more of a, it's a request. It's softer. It's not as strict. And they also cited another clause which granted the trustee sole discretion. So he had sole discretion to make a division of assets in kind or in cash. It was totally up to him. So the court found that read together, the trust provisions permit the trustee to exercise his discretion to make an in-kind distribution to the beneficiary instead of a direct sale and distribution of the proceeds. So the court agreed with the museum that the Bosch Trust cannot be interpreted as mandating a sale, but they really couldn't side with its further contention that the trust requires the trustee to give it in kind. So they weren't super helpful, and they basically kind of came down in the middle. So they ended up vacating the probate court's decision, but they remanded it back to the probate court and basically told them two things. They said, one, decide whether Mulvihill needs to be removed as a trustee. So, is his conflict too strong? Does he need to be removed? And two, if he doesn't need to be removed, the probate court will issue a new order instructing Mulvihill to exercise his discretion and just make a decision. So they basically said, we're not telling you what to do. Go back and make a decision. Pick a side and use your discretion as is given to you under the trust and figure it out. So again, the court not being overly helpful. But let's talk for a minute about why this was such a fight. Why would this art museum in Germany want to take this distribution in kind, half of 4 rental properties in San Francisco? What is the logic there? So as I said before, usually charities prefer cash over a deed, right? That is preferable. So what could be the reason as to why they wanted this in kind? Well, if Bosch's trust share of the subject properties is sold directly by the trust will suffer a significant tax consequence because it's 50% interest. To be specific, it has a low cost basis. And that's because Bosch died in 1995. And when Hudson died in 2019, the property value increased greatly. So imagine, the swing in the market these days, how much more rise in value these properties have. So that's why there was going to be a big tax consequence. So because of this large tax consequence, if the proceeds were liquidated, that would have significantly reduced the distribution to the museum. But if Stadel took title instead, and then after tax sales proceeds, cash, it could, as a tax-exempt organization, sell its interest in the properties with no tax consequences. So, it just kind of depends on how you do it. So basically the museum was saying, give it to us in kind, then we'll sell it and we'll have no taxes to pay. So that was kind of their reasoning. And if you look at the Hudson Trust or the Hudson Charities, those 4 folks in San Francisco, they didn't have the same problem, right? So the Hudson Trust 50% interest only received a step-up basis at Mr. Hudson's death in 2019. So there was very little step-up basis there, and therefore their trust would not have the same tax consequences. So they didn't really care. They said, just liquidate it and give us the cash. That is what is better for us. Plus, as everybody knows, they wanted to avoid any potential environmental and liability issues with real estate, as most of us do. So here we are. What are the solutions? As far as I know, at least in the last couple of days since finalizing my slides, there has been no resolution here. Mulvihill is probably still racking his brain figuring out what to do. But not that we have the perfect answer, of course, and we're not Mulvihill. We, not going to speak for him, but we were just kind of thinking about some potential solutions. And there's really 2 that we came up with. So the first one is, what if Stadel took full title or at least partial title to the properties? And then once they took title, they sold them and then sent cash to those 4 Hudson charities to make them whole again. That could be a way to dispose of the assets and make everybody happy. Or what about using a third-party donor advised fund? So what if they, because the DAF would take title, they would distribute the proceeds to the actual beneficiaries. And because the DAF is a charity, there's no income tax on the sale of the property. So this would help the Stadel group, it would help the Hudson charities, and hopefully everyone would be happy. So those are just 2 ideas that we came up with, but who knows? I'm sure Mulvihill is trying to figure it out. Okay, so let's see. We have 2 questions here. Okay, so we already answered one. Going back to the previous case, what is the burden to prove undue influence when the person being accused of undue influence is not a beneficiary? Oh, That's an interesting question. What's the burden to prove undue influence when the person being accused is not a beneficiary? It depends. I would say every state, I know for a fact, every state is different. So it depends on what state the estate or the trust is being administered in. So go check out those state statute and see what the burden is. Every state, again, is a little bit different. There's no kind of universal, like federal rule for undue influence. It really varies across the board. And in that case in Vermont, they really went kind of outside what is typical undue influence. Usually you think of undue influence as someone's pulling the strings behind the scenes. There's that manipulation, there might be a little bit of lying, they're convincing people to disinherit other family members, and there's usually a level of manipulation there. And the court didn't talk much about that in the Vermont case. So it depends. So I would say go look at the state statute and it will tell you the burden. All right, let's move on so I can hit these other cases. Okay, so this one's really interesting. This comes from Arkansas. So this is a case where there was a pay on death beneficiary switch up. So in September of 2016, Teresa James informed her husband of 13 years, Dr. Riccone, that she was leaving him. She, out of the blue, walked into his room and said, I'm done and I'm leaving. So he was obviously very shocked and very surprised and very upset. So 3 days later, Teresa filed for divorce, and immediately Dr. Riccone began taking inventory of all of his assets, and he wanted to know where everything was, where all his accounts were, who was the beneficiary, and he was doing everything that he possibly could to take Teresa off all of these beneficiary forms because he wanted to ensure she didn't get a dime. So again, he was going through all of his accounts, making sure she didn't get anything just in case he passed away. He changed his will, he gave everything to his 3 adult children, and he started going through all of his other accounts. He called Alliance Insurance Company to determine what, if any, policies he had with them and to ensure that his wife was named as a beneficiary. She was replaced. The Alliance representative informed him that he had a $300,000 term life policy, and he faxed over the paperwork right away. It's funny, in the court decision, they actually showed the transcript of Dr. Riccone and the person from Alliance, and it was a really interesting conversation. It was crystal clear that he wanted nothing but to remove Teresa from this account, and he wanted to do it immediately. So again, that was on the record, and again, his intent was very clear. So again, Alliance faxed over all the paperwork. Dr. Riccone completed it pretty much right away. And that same day, he faxed back the updated paperwork, leaving the policy to his 3 children. However, he didn't sign the document. So he did everything he needed to. He got rid of Teresa. He put in his kids' information, social security numbers, addresses, all that stuff. But he missed the box at the end asking to sign and date. And that's what he submitted to Alliance. So Alliance says that they sent him a deficiency letter a couple weeks later. And a deficiency letter is just something letting you know that, the paperwork you submitted is not complete. This part is missing, please redo it. So a letter was mailed to Dr. Riccone about a couple weeks later, noting that the paperwork was incomplete. Unfortunately, Dr. Riccone did end up passing away less than a year after that, and he never completed the forms. So these forms were left unsigned. When he died, naturally, Teresa completed the life claim form right away and was hoping to receive the funds. But the doctor's kids filed a declaratory judgment and made sure they got in the way of that, basically saying that it was his intent to change the forms. He did not want her receiving a dime, and therefore do not give her this $300,000 policy. So this went to the circuit court, and again, they hoped that they would be found the beneficiaries and not Teresa. The circuit court looked at the record and they found that Dr. Riccone, quote unquote, substantially complied with the policy requirements for changing the beneficiary designation. There was no evidence before the court that he received the deficiency letter, and the request to transfer ownership and or change beneficiaries form is ambiguous. And it was not clear that he had to sign at the bottom. So the court basically said, this is a confusing form. Clearly, he wanted to take her off. He did 99% of what he should do, and therefore we should, allow it and make sure the kids get the gift. Naturally, Teresa was not pleased, and she appealed to the Court of Appeals. So the Court of Appeals basically found that an unsigned change is not a change at all. So they signed with Teresa and felt that because he didn't do what he was supposed to do, because he didn't sign the form, that form should not be held, as final. So as you can imagine, the children were then upset and they appealed to the Supreme Court of Arkansas. So now we're at the Supreme Court, and the Supreme Court looked at the record, and they again looked at the past court decisions, and they held that under Arkansas law, only substantial compliance is required with insurance policy change of beneficiary forms. Sometimes this is also known as the harmless error rule. You might have heard that before in terms of wills that are incomplete or maybe missing a notary or a witness or something like that. So that comes up from time to time. This was definitely an unusual holding in Arkansas because they don't even have a harmless error rule statute. Usually it's in the statute somewhere based on the state, and Arkansas doesn't usually go by the harmless error rule. So this was really surprising. And this is something to keep in your back pocket here, because the lesson that we should all take away is that in Arkansas and even elsewhere, if a charity finds that you're on the short end of a troublesome beneficiary designation and you have a good argument that donor intent is on your side, you may not wish to abandon pursuit of the gift, or at least try negotiating a compromise settlement. So if you find that you're in this position, you should consider saying something, because if the whole record shows that, this person meant to make charity XYZ the beneficiary, but for some reason there was one tiny issue with the paperwork, depending on where you are, it could be found that the paperwork was in substantial compliance, and you want to honor the donor's wishes, and their wishes were to give you that gift. So always keep this in mind when you're working on these beneficiary cases. Okay, couple of questions. Let's see. What factors determine the state for court venue? Oh, residence at time of death, or the state, I think it means state last will trust document, especially with regard to undue influence. That is a great question. So usually it's where the person passed away, but there are certain cases where people move, right? So they have a will that was executed in Wyoming, but then they moved down to Colorado. What is the court venue? So again, it depends, but usually it's the place of death. Usually it's where the person passed away. That's where the estate administration is gonna be held. Okay, 20 years ago, a home was left to a charity for use to run a boutique teaching sales to women in recovery. If the charity ever ceased to run a boutique, property reverted back to the son. Okay, the son, Mr. Smith, is now 90, doesn't want the home or tax consequences. He's selling the home outright, doesn't want a tax consequence. He wants the foundation to receive the proceeds. He has a realtor. Should their transaction be in kind or at the closing? Oh boy. Why don't you email me? Let's talk about this, because I think this is a bigger question that I can give a bigger answer offline. So shoot me an email. Okay, last question. On this particular Arkansas case, it seems that substantial legal fees would be incurred. Did the kids pick up the legal fees? That is a great question. I didn't focus on that when I was reviewing this, but usually you can ask the other side to pay legal fees. If you're the winner of the case at the end, you can ask for the court to award legal fees to you, meaning that the other party would have to pay for your legal fees. So that's a great question. All right, moving on. I want to hit these other cases before time is up. Okay, so let's talk about interorum clauses. An interorum clause is another way of saying a no contest clause. So you have probably seen this in different wills and trusts before. Usually it's kind of snuck in at the end there, and it says something about, and if a beneficiary should object to this will or trust, then they should be assumed to have predeceased me. So basically saying that their gift is going to disappear and go away if they say anything. Usually this is meant, and it's stuck in there to convince people to not put up a fight, right? To not get upset if they're disinherited. Usually it's for, those family members who are left out or who are maybe getting less than they anticipated. But what's interesting about these is, how are the clauses triggered? There's a lot of questions these days about what actions do I have to take to actually trigger this clause? What if I just want to file an appearance? Will that trigger the clause? What if I just want to ask for a, construction pleading? Will that trigger the clause? What really rises to the level of filing an objection or triggering this clause? So let's talk about two different cases. Well, actually, hold on, let me just make sure I had all my notes on that. Okay, so before I get into the cases, one other thing to note is that usually, from what I've seen in the work and that I do, and we've handled a lot of cases across a lot of different states, usually if you have a good faith basis and you have probable cause to submit an objection or a question to the court, usually the court will not, choose to trigger this clause and disinherit you. If you show that you have a good faith basis and that there's probable cause to question what's going on here, usually you will be fine. But I say usually because, again, I don't want anyone to mistake what I'm saying. The clauses still have teeth, right? We should still be concerned about them. We should still tread lightly. And we should always be wary of raising issues in estates or trusts where a no contest condition is in place, because the provisions can be triggered in interesting ways. So with that said, let's talk about the first case. So this is the Miri versus Shantubi case over in California. So this is an unusual no contest case. California law permits probable cause challenges. Here, the plaintiff made a credible challenge to a no contest trust, but she filed it well after the filing deadline. So it was, a long, long time after her deadline to object. So unfortunately, the court not only rejected the challenge as untimely, but it also stripped Miri of her inheritance. The court reasoned that since a time-barred filing will likely be rejected, it cannot, by definition, have probable cause for success. Therefore, she triggered the full consequence of the no contest clause by filing her tardy challenge. So again, be really careful here. Don't file something just for the sake of filing it. Be, very cautious and just think through whether you want to go down this road. The next case is the Schlossberg case. So this raises the question of when the probable cause of a challenge is determined. You would think that the assessment is made at the time of the filing. So, what did it look like when this person actually filed a objection? But Schlossberg points in a different direction. So the decision states that if the entire trust is deemed invalid, so for some reason, again, maybe it was capacity or undue influence or something else going on, if the entire trust is deemed invalid, the no contest clause ceases to have a legal effect. So it won't be used if the whole trust is deemed invalid. However, the court preserved the possibility that a reasonable but ultimately unsuccessful challenge to a trust would subject the movement to disinheritance. So again, be really careful, tread lightly, and make sure you talk to an attorney before going down this road. I just want to say too, there are all certain circumstances that could trigger these clauses. We have a case right now in New York, and I was talking to one of the attorneys who represents a different beneficiary, and she was even afraid to file her appearance. She didn't want to file an appearance because she was afraid that this would trigger the no contest clause. Personally, and again, this is just my opinion, take it with a grain of salt. I feel like that's extreme. Everyone has a right to file an appearance and just watch the docket. You can just put your name in and say, I just want to see what's going on. I want to make sure I have notice of the documents. You can play it, really casually. It doesn't mean you're going to file an objection. It just means you want to follow the case. So again, just to show the kind of wide range of opinions here, some are even afraid to file an appearance. So, just keep that in mind as you move forward. Okay, making sure I've answered all these questions. Okay, yep, I think we're good. All right, so let's move on to our last case. So this hails from Pennsylvania. So this case really reinforces the importance of a careful review of every probate-related document. Here at CCK, we request every single document related to the bequest administration, and we review it thoroughly, because I can't tell you how many times there have been little things that sneak in here and there that are red flags to bigger issues, and that will, leave money on the table if we don't say anything. So Mr. Bavel passed away, and he left a 7-figure estate behind. There were 4 charities who were sharing the residue, and the will directed the executor to pay as an expense of the estate all death taxes, including Pennsylvania inheritance tax on gifts passing under the will. If anybody is not from Pennsylvania, essentially inheritance tax is imposed by some states on the recipient of an inherited asset. There's actually only 6 states in the country that have a inheritance state tax: Iowa, Kentucky, Maryland, Nebraska, New Jersey, and Pennsylvania. So typically beneficiaries do pay the inheritance tax out of their gift, not the estate. However, it's totally up to the donor, up to Mr. Bavel, what he wants to do. He can put whatever he wants in his will, and that's what happened here. So the testator, Mr. Bavel, was free to make an alternate provision, and he asked for the estate to pay the taxes on everything that passed under the will. Emphasis on passing under the will. Again, so although charities are exempt from the inheritance tax, payment of taxes from the estate has a trickle-down effect, right? So we don't want to pay excess taxes because that means less money for the residual charities. So here, the executor actually went above and beyond Babel's instruction. He paid inheritance tax on non-probate assets, such as IRA accounts. Those IRA accounts have a designated beneficiary. So these payments were noted on the estate accounting. I'm sure everyone has seen those accountings. They usually come at the end of the estate administration or usually towards the end, and it lists every single thing that went into the estate and every single thing that went out of the estate. And so it's super important that you review the accounting really closely because, like here, there could be a situation where the executor, this was a good guy. He was trying to do the right thing. He was trying to file, do everything by the book and follow his friend's instruction. So he had all good intentions, but he mistakenly paid extra tax. He paid tax that he shouldn't have. And again, this was noted on the accounting. Because it was noted on the accounting, thankfully, the Pennsylvania Attorney General's office had reviewed the accounting. They noticed that this extra payment was there. And on behalf of the charities, they objected to the use of estate funds for taxes owed by non-probate beneficiaries. So these payments, again, reduced the amount available for the charities, which is no good. The court agreed and found that Babel's will directed the assumption of the tax burden only for gifts made in the will. It said nothing about gifts outside of the will. So this resulted in the recovery of over $100,000. It was about $130,000 to be divided among the charitable beneficiaries. So again, this is fantastic. Attorney General's offices can be really helpful, but what's the lesson here? So the lesson here is even well-intentioned executors make mistakes. As I said, this executor was trying to do the right thing. He wasn't being evil. He wasn't taking anything off the top, for his own benefit. He was trying to follow his friend's wishes. So even if the will is clear, even if he is a well-intentioned executor, he made a mistake. So it's so important to look at those documents. As part of the stewardship of final gifts, it's crucial for charities to review the document, such as wills, trusts, and to verify the estate is administered according to plan. Again, if you don't, that could mean funds out of your pocket. So always take a look. And the last thing I'll say is that, as I mentioned, Attorney General's offices are fantastic. They usually have a stake in the game to protect charities. That's their role. However, they are incredibly backed up and incredibly busy. We are still suffering from backlogs from COVID, believe it or not, and a lot of the Attorney General's offices do not have time to look at every single document and every single line. The charities were lucky here because the Pennsylvania Attorney General caught it, but they don't always catch things. So do not just trust the fact that the AG is reviewing it. They'll catch it and we'll be fine. So always do your own check to make sure that everything's in tip-top shape. All right, so let me see some questions here. PA AG is great. Not sure we can count on all states to act in the same way. Yes, I could not agree with you more. Pennsylvania is awesome. There are some, again, this is no shade to New York, but the New York Attorney General's office is very backed up. They are so busy. They have a lot going on and they just don't always have time. So please keep that in mind. Okay, so I think that's good. Oh, Ashley, this was excellent. Thanks, Ashley. Appreciate it. All right, so that brings me towards the end of our presentation. Here are my contact details. Do not hesitate to shoot me an email or call me if you have any questions. If you're dealing with a tricky bequest, I'm happy to chat as a courtesy, pro bono, really just happy to be a resource and see if we can figure something out together. So I'm here if you need anything. Again, thank you for joining us today. Thank you for starting off your Labor Day weekend with us. And Brian, if you're still there, I'll kick it back to you.
I am. A great job as always. I've typed in a couple comments there. As I mentioned, we're going to have the full, and I'm going through a car here, so we got some weird, weird shading going on. But we'll be able to send out the recording next week with all the Q&A. Any questions anybody has for Lindy or myself, obviously feel free to reach out. But Lindy, fantastic job as always, and just really helpful, frankly, how practical these things are. And hopefully if you are a charity or professional advisor working on any kind of estate settlement, these more recent cases, I think, can be very telling in terms of what opportunities sort of may exist or other ones that perhaps may not. So, but Lindy, great job. I will see you in person here in the next couple of weeks, and appreciate again your help today.
Awesome. My pleasure. It was great to see you, Brian. Great to see everybody. Thank you.
Great. Thanks, guys. Have a great day.